Hi, everyone. This is Carol Williams with Williams Immigration, and welcome back to another Monday morning of Beyond the Soundbite, where we talk about all things USA immigration related. So, I like to dive right in. So, the first thing I want to talk with y'all about this morning is adjustment of status applications that are based on employment, green card applications that have an underlying I-140. All of those adjustment of status applications, so all of your 485s, you will most likely soon be getting a transfer notice. The transfer notice will let you know that your adjustment of status, if it is currently filed with Nebraska or the Texas Service Center, will be transferred to the National Benefit Center. This applies to all of the adjustment of status cases except for those that are in the fourth employment-based category. Those will still be processed at their current service centers, but all other cases are going to be slowly moved to the National Benefit Center. So if you get a transfer notice of your currently pending adjustment of status case that is currently at Nebraska or Texas, and it's going to the National Benefit Center, that is on purpose and it is not a mistake. The second thing I wanted to talk to y'all about is it's a new policy update. And frankly, this is a significant change for the Immigration Service. If you were granted conditional permanent residence, meaning if your spouse sponsored you for your green card and when it was approved, you all had been married for less than 2 years, you were issued conditional permanent residence and your green card itself is only valid for 2 years. So close to the end of that 2 years, we need to file what's called a removal of those conditions to convert your status from conditional permanent resident to a true permanent resident. And then you would be issued a 10-year green card. As part of that application process, there is an interview of the couple at your local immigration office. Well, immigration is now really trying to work through their backlog. They are using a risk-based approach in this new policy, which is effective immediately. And this new policy is exempting certain applications from that interview. So you essentially, if you meet the new requirements, do not have to go into the office for an interview. They can and will begin approving applications based on what you filed without calling you and your spouse to the local office for an interview. So what needs to be shown in your application in order for you to be exempt from the interview requirement is there needs to be a sufficient amount of evidence submitted about your marriage. Is your marriage real? The second thing they're looking at is, do we have a joint filing with both spouses? And if they are eligible for a waiver, again, do we have enough information about the marriage in that application? There needs to be absolutely no indication of fraud whatsoever contained in that application. The application cannot be it cannot be complex. It cannot be one of these super complex applications for the officer. And there cannot be any criminal history that would render the immigrant removable. So essentially, we are looking at some what I like to call really cookie cutter, plain Jane basic removal of condition applications. But if your application fits under this new policy, then you will not be required to appear at a local office for an interview. So this is tremendous news. It will help with efficiency within the agency. It will cut down on the just the sheer amount of manpower and time spent on some of these applications when you consider adding in the time spent to prepare and conduct an interview. So that is great news for those individuals that will essentially file for their removal of conditions application. And then the next thing they know, they will not be getting an interview. Instead, they will be getting a 10-year green card in the mail along with an approval notice. So again, that policy is new and it is effective immediately. The next thing I want to talk to y'all about is the expansion of premium processing. I've been talking about this for a little while now, and I'm going to keep talking about it. The final rule allows for a phased in approach of premium processing. So, premium processing, if you're not aware of what it is, premium processing is a way currently for some employment based applications to be processed in 15 calendar days. So, in those 15 calendar days, we either get an approval, a denial, or a notice of request for further evidence. So, but 15 days, 15 calendar days is so much quicker than waiting several months for the Immigration Service to process the application. We are now looking to see an expansion of applications that are available for premium processing. But again, this is going to be a phased in approach. So I want to kind of run through some of the applications that we're going to see eligible in the future for premium processing. So I-140 applications, which we all know is part of the employment-based green card application. We're looking at EB-1s, multinational executive or manager applications, the I-140 only. We are looking at a 45-day processing time with a filing fee of $2,500. We're also looking at EB2s, advanced degree, exceptional ability, and national interest waiver applications. We're looking at a phase in of those in fiscal year 2022 with a 45-day processing period and a premium processing filing fee of $2,500. We're also looking at adding our change of status to F1, student F1s and their spouses and dependent children, J1s and their spouses and dependent children, as well as M1s and M2s. For those, we are looking at a 30-day processing time with a filing fee of $1,700 for the premium processing request. And we're looking also to see those phased in fiscal year of 2022. Slightly further out, we are looking at change of status or an extension of stay in E1, E2, E3, H4, L2s, O3s, P4s, and R2s. Those would have a processing time of 30 days with a filing fee of $1,750. This particular category is quite significant because the principal applicants currently are eligible to apply for premium processing. However, what we are seeing is that while the principal applicant's application is adjudicated in 15 calendar days, their spouse and children are having to wait much, much longer for their dependent approval notices, which, as you know, affects travel, affects family, and just affects what's happening at home. So we're looking again at a phase in of that in fiscal year 2025. We are also looking at premium processing opening up for employment authorization cards, otherwise known as EADs. The processing time for that would be 30 days with an extra filing fee of $1,500. Now, this is going to have a slightly different phased in time. Students and exchange visitors applying for optional practical training or OPT, we are looking to see that phased in fiscal year 2022. All other employment authorization document applications, they are looking to phase in the premium processing in 2025. So, given that fiscal year 2025 is a few years out. You all will be hearing me giving you updates on the phasing in of this if they should choose to speed up the phase in sooner. But I will certainly keep you updated as those specific dates become available for the expanded premium processing. And again, these are expanded premium processing for employment-based applications. So if you have any questions about what that means for an application that you potentially are looking to file or an application that is already filed, please feel free to reach out to my office, 954-903-1337. The next topic that I wanted to talk to y'all about is TPS has been granted for those individuals from Cameroon that are currently in the United States. DHS recently made that announcement. TPS will be granted for 18 months. We are now simply waiting on that to be officially published. And when it is officially published, I will have those dates for you, the beginning and end dates of the 18 months. But as of right now, individuals who are from Cameroon are going to be receiving temporary protected status, otherwise known as TPS. The next thing I wanted to talk to y'all about this beautiful Monday morning is if you receive a request for further evidence for a medical and you have applied for a green card and your adjustment of status is pending, the request for additional evidence means that you did not submit your medical at the time when you initially filed, which is perfectly fine. It is not required. Or perhaps you did submit it, your application has been pending for quite some time, and your medical has now expired. The medicals are not valid indefinitely. But if you get a request for further evidence for your medical, run, do not walk, run to have that medical done by a USCIS approved physician and send that back into the Immigration Service. This means when you get this RFE that the Immigration Service has basically taken your file off the shelf and it is ready to process your application. Someone has looked through it and determined this is the only thing that is needed, assuming this is all that is requested in your RFE. I have had cases where the only thing that was requested in the RFE for the pending adjustment of status has been the medical. And as soon as we got the medical in, shortly after that, we received an approval notice for the green card without an interview. Now, I certainly can't guarantee you that you won't have an interview, but it certainly means that the Immigration Service is in fact processing your case and that it is on someone's desk. So you always want to make sure that you respond to the RFE. Surely if all they're asking for is the medical, you want to run and not walk to have your medical taken, but make sure that it is done and that the form is filled out by a physician that is approved by the Immigration Service. And the last thing I wanted to talk about this morning, I know you guys thought I was done talking about this for a little bit, is the H-1B lottery. So on the off chance that you have not checked your MyUSCIS account, go ahead and do that. If your status says selected, it means that you are able to file your full H-1B application. If the status still says submitted, it means that you are not selected in the lottery. Now, for the past couple of years, the Immigration Service has run multiple lotteries. In fact, last year was the only time since they have started with the electronic registration for the lottery. It was the first time they have actually run the lottery 3 times. So we don't know if there will be another lottery round. We just simply don't know yet. But you want to make sure that you go back in and keep checking. And of course, I will keep you updated here. But if you have not gone into your MyUSCIS account, go into your USCIS account, check the status. If it says selected, then you may file your full H-1B application. So that is all I have today for Beyond the Soundbite. If y'all have any questions about U.S. immigration, feel free to give my office a call, 954-903-1337. I am Carol Williams with Williams Immigration. Have a wonderful rest of your Monday and a great